Hi, everyone. My name is Kevin Mason. I am an attorney here at Tucker Allen, and today I will be acting as your moderator for this Facebook Live session. Jim will be the speaker today, and I'm going to go ahead and let him introduce himself.
I'm Jim Gao, also an attorney at Tucker Allen in the St. Louis area. Been an estate planning attorney for 11 years now, and hoping we have an exciting topic for you today.
Yeah, absolutely. So today we're going to be talking about beneficiary designations, but really quick before I kind of hop into some questions that I have for Jim about these, I just want to go ahead and state that today what we're doing is for educational purposes only, and this is not intended or going to form a attorney-client relationship. So with that out of the way, Jim, maybe could you just go ahead and just, describe or just tell me exactly what is a beneficiary designation?
Right. So, almost everything has the ability to put a designation for who you want to get your assets when you die. So, it's a non-probate transfer is what they're called. Whether it's a, real estate, you would record a beneficiary deed, or a transfer on death instrument is what it's called in Illinois, and some states it's called transfer on death deed. Usually your cars have a spot when you apply for the title to do a transfer on death or a TOD. Bank accounts have pay on death beneficiary designations, POD designations on bank accounts and cash accounts. And then, life insurance and retirement accounts, you always have a form that you can fill out naming a primary beneficiary and a contingent beneficiary in the event that first primary beneficiary, passes away or something happens to them first.
Gotcha. And just real quick, is there any real difference between like the payable on death or the transferable on death?
Not really. They're just called different things at different institutions. At the end of the day, if you think of it, it's a contractual relationship between you and the account holding institution. Basically, you say, "Here, I'm gonna let you hold my money, and we'll sign this paperwork saying that when I die, please give it to these people."
Yeah, so it's the same either way. It's just depends on the asset a little bit, maybe, or the place that you're doing it at. All right. So I guess my next question is going to be, should people have beneficiary designations on their accounts?
So the answer is always going to be yes. So it's always yes. Like I said, they avoid probate. It's a very quick and easy transfer to get the assets transferred. Basically, you just produce a death certificate and they move the account to the person's name, whether that's writing a check or changing the account, like rolling it over into a new account in their name. IRAs, for example, you get an inherited IRA account when you're the beneficiary on an IRA. So it just really depends on who you're naming as that beneficiary. So
Gotcha.
If you've got an estate plan that has a trust in it, the trust is going to be the beneficiary, not an individual. Because if you named the individual, it would completely just eliminate the need for the trust, and it would circumvent all the terms in the trust. So, if you put any kind of qualifiers on inheritances or anything like that, if you leave them beneficiary to the person, then those aren't going to happen anymore.
Right. Okay. And so we kind of think of probate as kind of this bad word, maybe, because we want our clients to avoid probate. It's time consuming, it can be expensive. It's just not something we wish our clients to deal with. So, since a beneficiary designation, it avoids probate, then that means, again, the answer, this is something that everyone should have. Depending, on how it's used is going to be dependent on whether it's used in conjunction with a will or in conjunction with the trust.
Right. So if you've got an estate plan, like I said, that uses a trust to do the majority of the planning, then you want the beneficiary designation to go to that trust so that the documents then, the terms of the document apply to that asset after you die. If you have an estate plan that relies on a will, so the will guarantees that you have to go to probate. So you probate a will by definition. And so if you have a estate plan centering around a will that says, "Dear Judge, this is who I want to get my stuff," then you actually would be probably better off leaving it most of the time, the beneficiary directly to those people, especially if there's no terms in the will for the inheritance or anything like that. You would be more likely or better suited to make the beneficiary the person in that scenario.
Gotcha. So Kind of just, I guess my next question is, what are the potential, I guess, downsides to only relying on, like a will plus the beneficiary designations?
So the trust gives you, or a trust plan gives you a lot of opportunity to put terms on inheritances. So if a beneficiary ends up with a drug, alcohol, gambling problem, just a lawsuit, a bad marriage, leaving them as the beneficiary individually on your accounts, the bank account, you take, for example, life insurance.
Mhm.
The life insurance policy pays a check to the people that you have named beneficiary. They then take that check and put it in their joint marital account and then get divorced. Whoops, there goes half of that life insurance money. So leaving it to a trust, though, you can keep it in a secure lifetime trust account for them where it's protected from things like abuse, substance abuse, divorce, lawsuits, stuff like that.
Yeah. And so just, another thing that I'm thinking of right now, let's say like your beneficiary designations, that's something that whereas in a trust, we can kind of line out and say, hey, if this person, predeceases me, then this is where I want the assets to go. With the beneficiary designation, is there any way to kind of say, if I name my sister or something and she predeceased me, what happens at that point then?
Yeah, so I see it all the time where, a couple gets a life insurance policy when they get married and buy their first house, and they get this life insurance policy to help in the event one of them dies, pay off the house. Well, then they have kids and they don't necessarily, the first call coming out of the delivery room isn't necessarily to MetLife or Prudential
Right.
to update that policy. So then, they go on down the line, never change it, husband or wife dies, and then the kids aren't ever actually added on there. Or, we've got 2 kids, we've got a life insurance policy, we had a third kid, forgot to put him on there as a beneficiary. So now the 2 kids get half and half when, the third one's just left out in the cold on that life insurance policy potentially. So you definitely have to keep the beneficiary designations. You can name a primary, you can name a contingent on most accounts, but you have to keep them updated. You got to keep adding people as they come into life and removing people as they pass away.
Gotcha. So that's kind of one of the ways that where if you have the trust, this investment account TOD to the trust, then that kind of can make it to where you don't have to be as, you don't have to watch those beneficiary designations as closely, right? Because we have this trust document that kind of, the trust isn't going anywhere. And the trust, we have set up these contingencies for all of the children, or if a child predeceases or something like that.
Right. Yeah. So you name the trust as the beneficiary one time. You're not changing it, potentially ever. But you could change the trust as much as you want because it's a revocable trust. But you don't have to go to the separate, different, account holders and institutions and change those beneficiaries every time something happens. You can just change the one trust document. Or like you said, we've built in generation upon generation in this trust of, kids, grandkids, great grandkids inheriting, and it's already written in there.
Gotcha. All right. Well, do you have any closing thoughts or one just piece of advice you want to leave us with?
So, make sure your beneficiaries are current. All they're going to do is if you name all these people and have the best intentions and they all end up passing away or before you, or you've got one beneficiary and that beneficiary passes away, the beneficiary designation itself avoids probate, but if there's no beneficiary left on the form, it's going to have to go to the courts. And then, after that, trusts are really for everyone. And it makes so many things easier, including beneficiary designations, to just name one entity, one trust, and set it and forget it. As I think it was the Showtime Oven said that. But yeah, so it's just get your estate planning done, get it done in depth, and don't rely on a simple solution like a beneficiary designation.
All right. Well, awesome. Well, I really appreciate your time today, Jim, and hope you have a good weekend. So thank you.
Yeah, holiday weekend.
Yes.